I'm now going to have a look at some of the questions that have been sent through and do my best to go through and answer those before I will pass back over to Anne-Marie. So let's see what we have. Okay, so first question we have is, if we do decide to appoint an EU representative, can they be held responsible for any enforcement action by the ICO in place of us as data controller? This is a very good question, and I think as a starting point, I need to just run over again the role of a representative. So the representative is really just fulfilling the function of an administrative hub for the data controller or perhaps the processor. And the representative is serving as their point of contact for data subjects and also for the supervisory authorities. This means that a representative doesn't actually affect the responsibility of the data controller or the processor under the GDPR. And the GDPR doesn't actually state anywhere that there is a substitutive liability of the representative in place of the controller or the processor. However, as I mentioned on my slide, there is the possibility for a representative to be directly liable, but this is really limited to the direct obligations of a representative. So for example, the failure to maintain a record of processing activities or for its failure to provide information to a supervisory authority. So in a nutshell, no, a controller cannot be absolved from being held liable for breach of its obligations by passing the buck essentially over to the EU representative. Okay, the next question is, which party is responsible for implementing the standard contractual clauses? Again, this is a very good question, and this is actually one that I have seen come up quite a lot in terms of my own clients. So Article 46 of the GDPR states that if the controller or processor is transferring personal data outside the EEA, an appropriate safeguard should be in place. So this suggests that it's the party transferring the personal data outside of the EEA, but by the same token, it doesn't specifically state which party is actually responsible for implementing the standard contractual clauses. And in reality, both parties should work together because, as I mentioned during the presentation, it really is in both parties' interests to have an appropriate safeguard in place if it is required, because both parties will want to ensure that any transfers of personal data are taking place lawfully. We are a processor based in Northern Ireland, but we will be receiving personal data from another processor based in the EU. What safeguards should we rely on? So this again is one of those funny situations that isn't strictly speaking covered by the standard contractual clauses. And this is something that we are hoping is going to be addressed going forward, because it's one of those scenarios that falls into the gap within the standard contractual clauses framework. Some companies have generally been implementing the standard clauses anyway, even if they don't specifically fit to their transfer scenario. And actually this issue was raised at the ICO Data Protection Conference back in 2019. And at the conference, the ICO said that you could actually just implement the controller-to-controller clauses, because this would demonstrate that contractual protections are in place. Again, I've had this issue come up once before. It wasn't in the processor-to-processor context. It was actually an EU processor to a controller in a third country, and in that instance what we did was we actually did just implement the controller to controller clauses, because we took the view after assessing the particular data transfer that it was better to just show that you were being proactive and trying to ensure that you had a protection in place than just simply doing nothing. Another option again would be to consider if one of the derogations under Article 49 could apply. But again, I appreciate that these really are only intended to apply in limited circumstances, so the likelihood of this is probably quite low. But again, I would recommend just really keeping your eyes peeled for any guidance from the ICO in this regard. Do we need to update our contracts to reflect that the UK is no longer part of the EEA? yes, you should indeed update your contracts, particularly any data processing agreements that you have in place. Again, as I mentioned during the main presentation, it's likely that this will be a pretty straightforward exercise, and you could simply just update the data protection legislation definition to reflect the UK GDPR. And in practice, I have seen this done by simply stating that any definition of data protection legislation will cover any subsequent or replacement legislation in force from time to time following EU exit. As I noted in the main presentation, you're also going to need to check any provisions on international data transfers, and you're going to need to see if they state that no personal data will be transferred outside of the EEA, because if they do, you will obviously need to adjust this clause to reflect that the UK is no longer part of the EU. Okay, the next one is we are headquartered in Dublin with a second office and DR in Belfast. Does DR backup data outside the EU still fall under the same law as live data? Yes, if it is personal data, so if it's information related to an identifiable individual. And as I mentioned, the definition is very widely drafted, so this could be even information pertaining to an ID number or initials of an individual that they would have the scope of being identified from. And yeah, so turning back to backup data, so this means that even if the backup data contains personal data pertaining to an individual, then it would be covered by the EU GDPR. So essentially the crux of this is really whether the information contains any personal information within it. The next one is, some of our employees have NI employment contracts, yet they reside in the Republic of Ireland. What is the position with them? This is actually a very good question, and it's something, again, that I'm seeing come up time and time again in practice. The question is quite general, so I'm presuming that these individuals reside in the Republic but carry out their work in Northern Ireland. If so, this is fine for their employment contract to be governed by NI law, as they're actually carrying out their duties in Northern Ireland. What I would say is that this situation is a bit different than what we have discussed during the slides, because it's not really in the context of a data controller in the EU, for example, the Republic, sending personal data to a processor in the UK. Rather, it seems to be that the personal data that the employer has will likely have come from the employee. And this really means that the employee will be aware that their personal data is being processed or accessed within the UK. But I appreciate that employers do need to exercise caution where employee personal data is concerned, and also particularly if there's any sensitive personal data being processed about an EU data subject, so about an employee that is from the Republic of Ireland. Unfortunately, in this situation, there are derogations under Article 49 that could actually be relied upon. So the main ones are probably that the transfer of personal data is necessary to perform a contract with the individual, so that would be the employment contract, or also potentially that the individual has explicitly consented to their data being processed outside of the EEA. Again, that question sent in was quite general, and if you do have any specific concerns with regard to cross-border employees, then I would recommend that you do obtain specific advice on that. I think I have time for a couple more. Can a UK software as a service host data for UK and EU clients in the UK and also in the EU for UK clients? So firstly, we'll look at whether a UK SaaS can host data for EU clients in the UK. Again, this is fine, provided that there's an additional safeguard in place. And this is because if clients are based in the EU, they are EU data subjects, and then they will be bound by the EU GDPR. So if their personal data is going to be transferred in the UK, it must have an adequate level of protection. Turning the scenario the other way around, personal data pertaining to UK clients that's being hosted or stored within the EU, again, that's fine, because the UK government has said that it will continue to recognise the adequacy status of the EU member states. Okay, I think I have time for one last one. Let's see. Are there any additional obligations for transferring sensitive personal data outside of the EEA? No, not in relation to the actual rules surrounding the transfer. So in relation to the safeguards under Article 46 or the derogations under Article 49. However, it's important to note that in the first instance, in order to lawfully even process or be transferring sensitive personal data, you must be able to show that you can satisfy a lawful basis for processing under both Article 6 and Article 9 of the GDPR. This will depend on the type and nature of the personal data, but for example, if it's employee data, usually you will be able to rely on the additional condition under Article 9(2)(b). I think that's the correct subprovision, and it's the one that says the processing is necessary for carrying out employment law obligations. Okay, I think that takes me to the end of the questions. Thank you very much for listening and for joining me this morning. I'm going to pass back over to Anne-Marie now. Thank you.
Thanks, Joanna. Joanna, just I think there's one more question there. I think it might be useful to cover off. Someone asked whether there was any exception for Northern Ireland to Republic of Ireland. My understanding is absolutely not, just to clarify that last question.
You're correct, Anne-Marie, there's not.
Okay, perfect.
Again, the situation is very fluid. It is possible that further guidance could be produced in that regard, but at present, no, there isn't.
Great, okay, thank you. Listen, thank you very much, Joanna, for today. That's us almost finished. I know we got a lot of questions through. We haven't got to absolutely all of them, but we will be reviewing them, and if we need to make changes to the frequently asked questions on our website, we will do so. As Joanna said, I know a lot of you are looking for other information and where you get other guidance. The Information Commissioner's Office website, ICO website, probably should be your first port of call when you are looking at data, and as Joanna said, a lot of the information is being updated. We also continue to update our business website, nibusinessinfo.co.uk, with the latest government guidance and advice, and also investni.com with frequently asked questions, articles and information. And I know that we are going to be doing a data article feature in the next couple of weeks, so keep an eye out on that. I've also put some useful links on screen that will help you to sort of find and navigate your way around. We have an online EU exit resilience tool on investni.com. It will take 15 minutes to complete and can help you identify areas that you need to focus on to prepare. So if you haven't already done that, I would recommend that you probably start there. We also have a number of EU exit webinars coming up. This is the second in our series today. We are going to be doing one on VAT and the Northern Ireland Protocol on the 8th of October, and we have a number of Brexit EU exit information workshops coming up at the end of October, start of November, and there'll also be sort of one-to-one advice appointments and extra resources at that. So if you are interested in seeing what sort of events we have coming up, if you go on to investni.com/events. If you also want those notifications to come to you, you can be notified of our latest events, news and support from InvestNI by signing up for our 2-minute update email newsletter at investni.com/newsletter. As I mentioned earlier, we have recorded today's webinar and we will send this out to you as well as a link to the presentation. So you'll be able to refer back to it, because I know Joanna covered an awful lot of ground there, and it would be useful for people to look back at it. So that's it for this session. I'd like to thank you all for attending and also engaging and sending in your questions. We'll review them, look at our website to update, and I hope that you have a great day. Thank you very much for attending.